It's been a lifesaver for millions of people in the UK, allowing them to stay at home to avoid spreading the virus while maintaining an income. But now the government's coronavirus jobs retention scheme, known as the furlough scheme, is tapering off.
Initially, the government covered 80% of pay, up to a maximum of £2,500 per month, and furloughed workers were not allowed to do any work for the company. Around 9.6 million workers were furloughed across the UK, costing £34.7 billion so far.
From July, workers have been able to return to work on a part-time basis, with their employers paying for the days worked and the government picking up the rest. From tomorrow, firms with staff on furlough will need to pay 10% of the wages, and the following month that will rise to 20% before the scheme ends on Halloween, 31st of October. The final bill for it is expected to reach £80 billion.
So the job retention programme changes at midnight. We're joined now by employment lawyer David Martyn. David, thanks very much for joining us. We've been told repeatedly that the furlough scheme is a mask for what will be an unemployment cliff edge. What should employees be looking out for in the coming months?
I think there's two issues we're really going to see. I think the first, which we're already seeing some examples of, are cases where we have employers who are disguising redundancy situations with other reasons for dismissing people. So we've seen a lot of cases coming through where people are being treated more harshly when it comes to disciplinary issues, perhaps people who are often long-term sick. And what we're seeing is employers using the opportunity of those other issues to dismiss people and not have to pay them redundancy payments. That's one of the things I think people have to look out for, is are we seeing redundancies being dressed up as something else? The other issue we've certainly seen a lot of is in relation to processes and failures in processes, particularly with large-scale redundancies. A lot of employers are of the view that, particularly if somebody has fewer than 2 years service, where you don't have unfair dismissal rights, that they can just dismiss people without any sort of legal consequences. But there are particular provisions in place about the process of the consultation that you have to go through before making redundancies that apply to everybody. And we've seen a lot of cases for what's called a protective award, where employers have breached those rights. So some really significant and busy employment law departments at the moment.
Are your terms and conditions the same if you're currently furloughed and then you're told that you're going to be made redundant?
Yes, that's been an interesting point which has been provided. We've had some clarity from the government on that. We would hope to see that most people's redundancy packages would be calculated based on their normal pay. So if you remember, a lot of people who have gone on to furlough have had their pay reduced to 80%. What has been argued for, and I think what the government has now accepted, is that it should be the normal pay both for your notice period and for your redundancy payment. The normal pay before furlough was implemented that should be used for calculating redundancy packages. I think the one thing to check for employees is, do you have an enhanced redundancy package in your existing terms and conditions? Because a lot of employees will have that in a policy somewhere, and if they do have that, that will give them more than the basic statutory minimum they would be entitled to.
How would you know then, as an employee, if you're told that you're being made redundant, whether that is, like you say, a sort of genuine consequence of the end of the furlough scheme or something else? How could you possibly find out?
Well, I think as part of the consultation that we talked about, you should be invited to discuss with your employer ways of avoiding the dismissals taking place and mitigating the consequences. And I think as part of that process, you're entitled to ask your employer to explain and provide some sort of evidence for the decision they're making in respect of redundancy. So you would expect to see significant reasoning behind a decision. There should not simply be a decision that's made within 2 or 3 days. There should be a long process of consultation where alternatives are explored and the nature of the employer's decision is properly explained to the employee.
Okay. David Martyn, thank you very much indeed for joining us.
Thank you.